So I really have just one question for you. How many of Epstein's co-conspirators have you indicted? How many perpetrators are you even investigating?
First, you showed it. I find it.
How many have you indicted?
Excuse me. I'm going to answer the question.
Answer my question.
No, I'm going to answer the question the way I want to answer the question.
No,
Your
you're going to answer the
theatrics are
question
ridiculous.
the way I asked it.
Chairman Jordan, I'm not going to get in the gutter with these people. All right.
My time. The answer to my question, how many of Epstein's co-conspirators has she indicted, is 0.
Pam Bondi walked into what she likely expected would be another routine congressional appearance, and instead found herself facing one of the most damaging public confrontations of her career. She entered insisting that every Epstein-related document in the Department of Justice's possession had already been released. Complete disclosure, total transparency, nothing withheld and nothing concealed. Then, a Republican member of Congress, someone with prosecutorial experience and ostensibly aligned with her politically, stood up holding records that appeared to dismantle that narrative point by point. He presented what he claimed was a detailed inventory of unreleased materials, internal memoranda, draft charging documents, and DOJ communications, records he argued were legally required to be disclosed. Bondi had little immediate response. Cameras captured the moment as the explanation she had repeated for weeks began unraveling in full public view. Now let's examine the point where lawmakers began pressing whether the DOJ disclosure had ever truly been complete.
I have 3 documents from the DOJ production that are emblematic of the massive failure of the DOJ to comply with the Epstein Files Transparency Act. To my right is an email that was sent by the victim's lawyers to the DOJ. It was a list of names not to redact, a list of names not to release. What did the DOJ do with this email? They released this email in the document production. Literally the worst thing you could do to the survivors, you did.
This matters because Bondi has spent weeks relying on the claim that complete transparency had already been delivered. She repeatedly told Congress and the public that every required file had been released, that the issue was resolved, and that continued scrutiny was driven by politics rather than legitimate oversight. Then a member of her own party challenged that position publicly and presented evidence suggesting the story was very different. According to the timeline under discussion, Bondi sent Congress a formal communication on February 14th, asserting that all Epstein-related materials held by the DOJ under the Transparency Act had already been turned over. Attached was a list containing roughly 340 names referenced within those documents, and the message conveyed was clear. The disclosure process was finished, nothing else remained, and further demands were unnecessary. Congress was unconvinced. Lawmakers reviewing the materials questioned whether what they received could reasonably be considered a full release because extensive portions had been blacked out. Large sections were redacted, significant details were missing, and numerous names did not appear. Members of both parties openly suggested that the disclosure resembled a controlled partial release rather than unrestricted transparency. Even with those concerns growing, Bondi continued maintaining that her department had complied fully with legal obligations, and that no relevant information was being withheld. The next development came when a Republican prosecutor began identifying specific DOJ records that had allegedly never been produced.
I don't answer a question the way you want.
This goes over 4 administrations. You don't have to go back to Biden. Let's go back to Obama. Let's go back to George Bush. This cover-up spans decades, and you are responsible for this portion of it.
And that's
now,
where the
I want to know, at what point did the FBI and the DOJ decide that Lex Wessner was not a co-conspirator? Because our Epstein Files Transparency Act requires you, please put it back on the screen, please, to release the internal decision about whether to prosecute him or not, and it's not in the files, and it's not in the files for any of these other men.
That argument has now come under direct challenge. During a later hearing, a Republican lawmaker with prosecutorial experience appeared prepared with records, oversight correspondence, and references to documents he argued had never been disclosed by Bondi's department. He proceeded through them one item at a time before Congress and national cameras. Among the materials discussed was an 86-page prosecution memorandum reportedly originating from the Southern District of New York. Also referenced was a draft indictment prepared in Florida concerning alleged Epstein co-conspirators. Additional records included internal DOJ email exchanges discussing charging decisions and debates over why certain individuals were not prosecuted. According to the lawmaker, each of these materials had appeared in prior litigation, internal inventories, or official references. He argued that every document fell within categories explicitly covered under the Epstein Files Transparency Act, and that none had been released by Bondi's DOJ. The implications became more serious because the dispute moved beyond broad accusations and into specific documented records. What intensified the controversy was not simply the suggestion that these documents might exist. The lawmaker argued that their existence could already be verified. He referenced case files where the documents had been cited. He pointed to DOJ inventories where those materials had reportedly been cataloged. He argued that the department had identified, organized, and accounted for these records, while ultimately choosing not to include them in public disclosures. If accurate, that significantly narrows available defenses. Bondi cannot argue ignorance if the materials were already documented within DOJ systems. She cannot dismiss them as irrelevant if they fall within categories Congress specifically requested. Critics argue that the evidence supports a conclusion that Congress was told all required materials had been released, while identifiable records remained undisclosed. What further amplified attention was the source of the criticism. The challenge came from a Republican rather than a political opponent, raising questions about how serious concerns inside her own political coalition may have become. Bondi's response reportedly relied on deliberative process privilege, a legal doctrine commonly used to shield internal government discussions from public release. That defense immediately became controversial, because critics argued the Epstein Files Transparency Act was drafted specifically to override those protections in this context. According to that interpretation, the statute requires disclosure of internal memoranda and communications discussing prosecutorial decisions, including reasons certain charges were or were not pursued. If that reading is correct, deliberative process privilege would not provide protection because Congress intentionally limited its applicability when crafting the law. Opponents argue Bondi understands this conflict, but continues invoking the doctrine because few alternative defenses remain available. Pressure intensified almost immediately afterward, with conversations expanding toward contempt proceedings and potential impeachment discussions. The political and legal consequences of these allegations could be substantial. Bondi's public defense for weeks depended on one central argument. Everything had been released, transparency obligations had been satisfied, and critics were misrepresenting the situation. If Congress can demonstrate that identifiable documents were knowingly withheld, that entire defense becomes significantly weaker. Lawmakers would then have specific records they could cite, and evidence suggesting Bondi was aware those materials existed while declining to disclose them. Before this confrontation, Bondi could plausibly argue that compliance involved difficult legal questions, and that disagreements reflected uncertainty rather than misconduct. Critics now argue that explanation no longer carries the same force if omissions involved clearly identifiable documents. They contend the issue shifts from a compliance disagreement toward potential obstruction. The consequences extend beyond a single hearing. If specific records were withheld, attention naturally turns toward what additional materials may remain undisclosed. Questions emerge about whether further memoranda, email exchanges, draft indictments, or investigative analyses still exist outside public view. The reportedly missing documents concern explanations for why certain Epstein-related individuals were never charged, meaning prosecutors may at some point have evaluated potential cases against additional people before stepping away from prosecution. Those internal analyses could reveal identities, evidence assessments, and reasons decisions changed. Supporters of the Transparency Act argue that these are precisely the categories of information Congress intended to expose when drafting the legislation. Critics now frame Bondi as the official standing between those records and public access. The missing Southern District of New York prosecution memo has become one of the most closely examined pieces because of what it could potentially reveal. The pressure surrounding possible contempt proceedings has intensified because critics argue Congress now has more than broad accusations to work with. They claim there are identifiable inconsistencies between Bondi's public statements and records that lawmakers say remain undisclosed. Supporters of oversight efforts argue this strengthens allegations that Congress may have been misled regarding the actual scope of released materials. If lawmakers conclude that non-compliance was deliberate rather than procedural, they could pursue stronger remedies, including financial penalties, expanded investigations, or additional oversight actions. The political impact grows even larger because the criticism is not coming exclusively from Democratic opponents. The allegations were raised publicly by a Republican with prosecutorial experience, creating the perception that concerns may extend beyond ordinary partisan conflict. That shift changes how Bondi may be able to defend herself politically, because arguments centered solely on opposition attacks become harder to sustain when criticism originates from within her own ideological camp. To understand why these disputed records matter, it is important to examine what supporters say the Epstein Files Transparency Act was intended to accomplish. According to that interpretation, the legislation was designed not merely to release investigative reports or witness material, but to expose internal DOJ reasoning regarding prosecutorial choices. The purpose was to reveal who was investigated, what evidence prosecutors considered, why charges moved forward in some situations and stalled in others, and how legal decisions were ultimately reached. Critics argue those internal explanations are exactly the category of information still being withheld. Among the most heavily discussed records is an 86-page prosecution memorandum reportedly produced by the Southern District of New York. Such memoranda carry substantial importance because they typically summarize evidence available to prosecutors, analyze potential charges, and document recommendations regarding who may face prosecution. In the context of Epstein-related investigations, observers argue such a record could identify additional individuals, describe relationships among participants, or explain decisions prosecutors reached while evaluating broader networks. Supporters of disclosure contend the document's existence has already been referenced in legal proceedings connected to Epstein-related civil litigation. Attorneys reportedly cited it, and references appeared in court discussions. If accurate, critics argue this means the memo forms part of the official historical record and cannot simply be dismissed as non-existent. They maintain DOJ possesses the material and that Bondi's department chose not to include it in disclosed releases. The discussion becomes even more controversial when attention shifts toward an alleged draft indictment prepared in Florida. Another disputed document drawing major attention is a reported draft indictment prepared in Florida involving alleged Epstein co-conspirators. References to its existence have reportedly appeared within court materials and internal DOJ records. A draft indictment represents a meaningful stage in any prosecution because it suggests investigators progressed far enough to identify potential defendants, outline alleged criminal conduct, and prepare formal charging language for possible presentation before a grand jury. Yet according to critics, those charges were never ultimately filed. That unanswered gap has fueled speculation. Questions emerge regarding whether prosecutorial priorities shifted, whether evidentiary concerns intervened, whether legal obstacles arose, or whether outside influence altered the course of events. None of those possibilities have been confirmed publicly, and supporters of disclosure argue that uncertainty is exactly why the document matters. If prosecutors were close to charging additional Epstein-related individuals before stepping back, observers say the public deserves clarity regarding who those people were and why prosecution did not proceed. Critics maintain the draft indictment could reveal identities, legal theories, and evidence assessments that remain hidden. They argue that withholding such material prevents broader understanding of how prosecutorial decisions unfolded surrounding Epstein's network and associates. Attention has increasingly focused on whether undisclosed communications inside DOJ may provide answers that public records still do not. The third category of disputed materials involves internal DOJ email exchanges discussing prosecutorial decisions throughout the Epstein investigations. According to allegations raised during the hearing, these communications include discussions among DOJ officials, prosecutors, and investigators regarding charging decisions, evidentiary standards, obstacles encountered during investigations, and debates over whether additional individuals should face prosecution. Critics argue these communications are precisely the type of internal transparency Congress intended to force into public view through the legislation. Bondi's position has reportedly relied in part on deliberative process privilege, a doctrine intended to protect internal governmental discussions. Opponents counter that the relevant statute specifically limits application of that protection in Epstein-related disclosures and requires release of memoranda, notes, and communications that would otherwise remain confidential. Critics argue Bondi continues relying on a defense the legislation was designed to override because alternative legal justifications are limited. Separate controversy surrounds the extensive redactions applied to materials that were released. The publicly disclosed documents contain large blacked-out sections, omitted names, and removed details. Bondi's supporters have pointed toward victim privacy concerns and ongoing investigative sensitivities as justification for those redactions. Critics respond that protecting victim identities is entirely appropriate, while arguing that concealing names of alleged perpetrators, associates, or other relevant figures undermines the stated purpose of transparency legislation. Lawmakers who reviewed less redacted versions have reportedly argued that information withheld extends beyond victim protection. According to reports discussed during oversight debates, several prominent names were removed from released records, despite later references surfacing in congressional settings. Critics contend those individuals may possess knowledge of or connections to Epstein's operations, and argue continued secrecy prevents full accountability. The controversy deepens further when criticism begins emerging from Republicans themselves rather than only political opponents. The political fallout surrounding these allegations has grown more complicated because the criticism is no longer coming only from Democratic lawmakers or longtime opponents. Bondi is now facing public scrutiny from a Republican figure with prosecutorial experience who appeared before Congress carrying documentation and argued that her statements about disclosure were incomplete or inaccurate. That shift matters because one of the most common defenses in Washington is to dismiss criticism as partisan attacks. That defense becomes harder to sustain when concerns originate from members of your own political side. The optics change entirely when allies begin raising questions publicly. Critics argue the emerging evidence has strengthened the foundation for contempt proceedings because lawmakers can now point toward specific categories of documents they claim remain undisclosed, despite repeated assurances that everything required had already been released. Supporters of oversight efforts contend this is no longer simply a disagreement over legal interpretation. They argue it concerns whether Congress received inaccurate information regarding compliance with disclosure obligations. If lawmakers determine those representations were knowingly false, the consequences could move beyond political embarrassment into much more serious territory involving obstruction and accountability measures. The debate has now expanded beyond transparency itself and into larger questions about institutional trust. If specific records remained hidden while the public was told complete disclosure had occurred, critics ask what additional materials might still be outside public view. That uncertainty is driving renewed demands for broader investigation, additional hearings, and stronger enforcement mechanisms. The pressure surrounding Bondi no longer appears to be slowing. Instead, conversations are increasingly shifting toward the most serious political consequences available. The discussion surrounding impeachment has grown louder alongside the controversy. Providing misleading information to Congress is a serious allegation, and critics argue that if Bondi continues refusing to release disputed materials after questions regarding their existence have been raised publicly, lawmakers may push for stronger remedies. Supporters of oversight efforts contend that obstructing congressional investigations or ignoring explicit legal requirements could fall within conduct warranting severe consequences. Whether those standards are ultimately met would depend on evidence, legal interpretation, and congressional action, but the conversation itself is accelerating. Calls for accountability that once appeared limited to a smaller group of critics are now reaching wider audiences, particularly as Republican voices enter the debate. That shift changes both the political dynamics and the public perception surrounding the controversy. Bondi's ability to characterize scrutiny as purely partisan becomes more difficult when criticism emerges from within her own ideological coalition. The broader issue extends beyond one official or one hearing. At the center of the controversy are unresolved questions people have asked for years. Who else was investigated? What evidence existed? Which individuals were considered for prosecution? And why were decisions ultimately changed? Were influential people protected? Or were prosecutorial decisions based entirely on legal considerations? Supporters of full disclosure argue the withheld documents may contain answers to those questions. Critics maintain Bondi's central defense has collapsed because she repeatedly asserted that everything had been released, while lawmakers now claim identifiable materials remain hidden. If Congress concludes those omissions were intentional, the consequences could become significant politically, legally, and historically. The investigation appears far from over, and pressure for additional disclosures continues to build. As this story develops, one thing is clear. The fight over the Epstein files is no longer only about transparency. It has become a battle over accountability, public trust, and whether powerful institutions are willing to reveal what they know. If more records emerge or new hearings take place, this story could shift fast. Subscribe, follow, and stay updated, because the next disclosure may answer questions that have remained unresolved for years.